This was just about the worst case nightmare scenario for Donald Trump, Department of Justice, and Lindsey Halligan, Donald Trump's stooge, his personal lawyer, who was picked by Donald Trump to lead the Eastern District of Virginia as the top federal prosecutor there to go after Donald Trump's political enemies like James Comey and New York Attorney General Letitia James. We all had been focused on the hearing that was going to take place this past week for vindictive prosecution. But then earlier in the week, we heard from the magistrate judge, Judge Fitzpatrick, about a whole host of misconduct that likely took place in front of the grand jury. Probably chief among them is the fact that the operative indictment was never provided to said grand jury. And so then this vindictive prosecution hearing that took place this week kind of spawned into this outrageous and gross misconduct before the grand jury hearing. And so it was something even more powerful on the Comey defense side than even the vindictive prosecution claim. So then on Friday, Comey filed this motion right here, labeled James Comey's motion to dismiss the criminal indictment based on the Fifth Amendment, Rule 6, and grand jury violations. Let's just let the motion do the talking right here, because if you're Lindsey Halligan, I think the best case scenario is that you get disqualified and the case goes away. Like, she's probably praying like for separate reasons. Can you just disqualify me? I was never really the U.S. attorney to begin with, just whatever. The next best case scenario is it just gets dismissed. I think the more likely scenario is it gets dismissed, and there are serious ramifications for her immediately in terms of her bar license. And then I think in a few years, accountability comes to Pam Bondi, who on multiple occasions as the Attorney General filed documents ratifying the conduct of Lindsey Halligan. And the reason Bondi filed these ratification documents was because she was trying to ensure that Halligan would not be disqualified by saying, I saw all of this, I supported it, even though my name's not on the indictment. I stand behind this, so don't disqualify her. But then Bondi worked her way into the bigger issue, which is now you just ratified and essentially de facto signed conduct that, we'll just use the words of Judge Fitzpatrick, puts us in uncharted territory where an indictment was signed but never presented to the grand jury. So here's Comey's motion. It says, James Comey, by and through undersigned counsel and pursuant to the Federal Rules of Criminal Procedure 12b, moves this court to dismiss the government's indictment. As explained in the accompanying memorandum, this case should be dismissed because the grand jury never approved the operative indictment. A grand jury may indict only if at least 12 jurors concur, but here at least 12 jurors did not concur in the operative two-count indictment, and the grand jury rejected the only indictment that the government presented to it. The government's attempt to prosecute Mr. Comey without a valid indictment of a grand jury violates the Fifth Amendment. Moreover, dismissal is independently warranted because of the government's misconduct before the grand jury. Among other things, the government relied on information it obtained in violation of the Fourth Amendment and the attorney-client privilege, and it made serious misstatements of law to the grand jury. Collectively, those violations raise grave doubt that the decision to indict was free from the substantial influence of the government's misconduct, warranting dismissal with prejudice. Let's bring in Harry Litman of the Talking Feds YouTube channel, the Talking Feds podcast, and the Talking Feds Substack, because in addition to being the lead federal prosecutor in Pennsylvania's federal court system, in addition to being one of the top federal prosecutors out of Maine Justice, in addition to running a great YouTube channel, Harry was in the courtroom when this all went down. Harry traveled to the Eastern District of Virginia Court, where Judge Nachmanoff was holding this hearing, and Harry saw it all went down. And we knew that there were issues from Judge Fitzpatrick's ruling, the magistrate judge, about a lot of things that went down that shouldn't have happened. The only FBI agent to testify was exposed to tainted information, attorney-client privilege information. We heard about Lindsey Halligan providing incorrect, erroneous, patently false legal instructions to the jury, basically saying that what Comey didn't really have a Fifth Amendment right and that the burden was Comey's and not the burden being the prosecution. And then you had Judge Fitzpatrick talk about this uncharted territory issue of, could it possibly be that the grand jury didn't see the operative indictment and the one they saw they rejected? And what the hell happened here? So Harry, you were there, bombshell after bombshell. What was it like being in court? And what did you see? And what does this all mean?
Yeah, man, oh man, it was really interesting. You know, I've thought of this case from the time they brought it as the single worst thing that Department of Justice ever has done. So, you know, I'm just bound and determined to follow it, but I had no idea what I was in for when I went out. So look, 85% of the hearing was just a very solid presentation on vindictive prosecution. Dreeben, who the attorney for Comey, a very well-known appellate lawyer, was making a lot of headway, and it was a straightforward. He had so much evidence to work on that made it clear, I think, to a normal person that this was all the reason that this was brought was because of Trump. And then the person, they can't even find anybody in the Eastern District of Virginia, the person that Lindsey Halligan had brought in from South Carolina, got up and basically tried to say, no, the real cause here was Lindsey Halligan and the grand jury that made their independent and determination, and Trump really is not the cause at all. So you're trying to figure that out because Nachmanoff wants to say, how did this work? She comes in 3 days before, and you're saying she made an independent determination, and they're pushing on that. And it was at that point that the issue came up, and he actually brought Halligan to the podium and made her say the point that now Comey is raising, which is, whoa. You had this 3-count indictment that they didn't go forward on. And the indication seemed to be that they just kind of took it and cut and pasted it and crossed this one out and renumbered. And that's what they served up to the court, meaning the actual operative 2-count indictment, the one that's in the file that charges Comey, the grand jury had never seen. Could this be? Fitzpatrick said it would be uncharted territory. As you say, anyone would know this is crazy. And that's what she fessed up to. She stood up and said, yes, that's what happened. And now, you had that kind of, you've probably been, crowded, quiet places where all of a sudden there's a, nobody can believe it. That was what was flabbergasting. But what's happened since, I think, is far worse. Well, let me, if you want, I want to set up today's even crazier, more squirrely and dishonest conduct by the administration. But that I not to get ahead of myself, Ben. So that's the deal. So we found out that, they turned down one indictment, and rather than taking the counts they had seemingly approved and going to them, new court reporter, new proceeding. Thank you, ladies and gentlemen. Here I'm presenting a new indictment. Please have a vote, etc. They just took the one that they partially rejected and, scratched it out and cut and pasted and said, here you go. And they then with a new whole copy that they, ran off somewhere in the U.S. Attorney's Office, that's what got handed up to the judge. That's what got put in the file. But it looks as if, and it's what Comey is saying, that was never actually looked at and voted on by the grand jury.
Right. So indictment 1 has 3 counts.
Yes.
The only indication on the indictment in terms of the statement of the grand jury is that they rejected the entire thing. It says all 3 counts totally rejected, which contradicts.
It doesn't exactly say that, right? But it says this package, we don't like it. Yeah.
We don't like it. Exactly. Yeah. But then the representations from the DOJ and Halligan was yes. That's because they just didn't like one of the 3 counts.
Yeah.
They were fine with the other 2 counts. But that's not what that first indictment says. So it's like, okay.
Oh, and more than that, it's not what Rule 6 says. The grand jury's rules say any indictment, the indictment has to be passed on by the grand jury.
right? So they reject that document. So Halligan not following, to your point, Rule 6 is like, well, if you just kind of like this and this, it's kind of like she's treating it like a buffet. I don't really want to eat the macaroni salad, but I want to eat that. And we're like, this is a grand jury. Okay, you take the buffet or you don't take the buffet.
Yeah.
So you got to present the buffet again fully to the grand jury and not be like, yeah, they wanted the chicken nuggets, but not the macaroni salad. And so then when she printed out the second one, she was supposed to show that to the grand jury. But instead, what she fessed up to is she just brought the foreperson and some other grand jury supervisor or someone who was there to the judge and said, can you sign this? And now in this notice of correction, she's like trying to blame, it seems like, the foreperson. Look, the foreperson said we were cool with all of this. And it's like, no, the foreperson's just a citizen who got a jury notice letter. And like the foreperson, you had to show it to all of the people. Like you're blaming the foreperson. So talk to us about what.
Yeah, I think they're doing worse. And you've been in this position, right, Ben? Like, oh my God, I may have misinformed the court. I have to file something that's called notice correcting the record. Oh man, well, I got to take my hits, fall on my sword, and make this exactly perfect. That's the exact opposite of what they've done. What they've done is try to take the same record, and if you read it carefully, they're not changing it. They're suggesting, but it's squirrely and deceptive, that in fact the grand jury approved the second indictment. That's what they're trying to sort of put over on Nachmanoff, who I think is going to easily figure it out and be apoplectic.
Harry, I'm going to toss it right back to you, but just I don't want people to think about this, which is Judge Nachmanoff's read the grand jury transcript. Separately, Judge Curry, another very esteemed federal judge who is dealing with the disqualification motion. Judge Curry, she's read it. And Fitzpatrick, these judges aren't dumb. Like, it's like Halligan thinks they're dumb and like, actually, look, the foreperson said that we approved it. You're missing the whole freaking point here. The is the operative indictment that you admitted to not presenting. You're not correcting anything. What you're trying to do is deceive the judges and treat them like they're stupid, and they've read this transcript. That's why they asked you, and Harry, you and I covered this for the past few weeks. We're like, could it be they didn't provide the operative indictment to the grand jury? That's why Judge Curry said, I think there's something missing here. It's the second and operative indictment. That's what it was. That's the whole thing.
And Fitzpatrick made it even more clear. He said, okay, there's no time to have done this. It's like would have been 7 minutes. So we have two possibilities. One is that Halligan's just a little confused, basically not telling the truth about what happened and how long it took. That's the first. Because the other is we'd be in the uncharted territory in which the government gives up, produces an indictment that the grand jury had never passed on. And I mean, that was such a dumbfounding possibility that he presented it as, I guess that's the only thing left. It was precisely that possibility that was established, or so it seemed, on Wednesday. So it had already been brought up. And to your point, Ben, you would think if that had happened, you'd have it'd be in the transcript, right? There'd be a grand, welcome again, ladies and gentlemen. Welcome, Mr. or Ms. Court Reporter. Now I'm handing up to you the new indictment that we hope will be operative. Nothing like that happened. So the big mystery was, how could they say? And the answer to the mystery was, oops, we didn't present it. And so, as you say, Comey's now come in guns a-blazing saying there's no operative indictment. Now, I want to emphasize on the law. Nachmanoff was ready for this, and he served up a case from the D.C. Circuit from a while ago, Skelly Wright. And it actually gives, it totally dismisses the government's trying to say, just a clerical error, as they're saying here. But it does give a test and a sort of opening to ultimately find that the indictment is okay and can proceed. But that's not what this is about anymore. As you say, there are other issues, and we can talk about them now or on a different YouTube, that really look very serious and the likely candidates for dismissal. But this is all about the credibility and competence of the administration, and that they're now coming in after this whole dumbfounding revelation and trying to suggest, but it's just not true, that the grand jury actually voted on the second indictment is just A, inane, but also B, so violative of the duty of candor to the court. They're really, here's what they say, at the end: the sworn testimony establishes the grand jury voted on the 2-count indictment. Well, that sounds like, I guess they did, huh? So that's why you're correcting. But if you look at it, it's just saying the foreperson, who, besides not being the whole grand jury, is just a lay person, right? I think is trying to explain, well, they voted on those 2 counts, but that's 100% missing the point. The administration knows the point, and this is, I think, 100% a ham-handed effort to pull the wool over the court's eyes. He's not going to appreciate it.
And the judge is actually giving an opportunity to the DOJ to correct it and fess up and admit it, and they're not doing it.
They did it Wednesday, and then the right
response would not be a notice of correction, what we said.
Right.
The right response would have been, we sent in someone who didn't know what she was doing, and she did indeed present the indictment, and they were good with these 2 counts, and she screwed it up.
Yeah.
She screwed it up. But what you need to realize is all of the evidence shows that they still supported these 2 counts.
Exactly.
But her declaration should be, I made a mistake and I made an error, and admit to it. That's what and she didn't see that that's what the judge was suggesting also. And she said, nope. Actually, what we said was,
and then worse, because she goes back. I'm sorry to interrupt. I'm all hot and bothered about this case, as you can see. But she goes back to DOJ, where there are people there who presumably are some form of adult supervision. So you're exactly right. What they should have said, and when they should have said it, would be in response to the motion to dismiss that they knew Comey would file, and indeed he has. Instead, they interpose this 2-page memorandum that has to be taken as, here's what really, really happened on this all-important question, as it's now been focused. Did the grand jury see and sign off on indictment number 2? And they file something that tries to sort of suggest it did, and if you read it carefully, it didn't. And man, I think they're going to get their head handed to them.
Oh, and you and I will do other videos on this, but that doesn't even get to the issue of, one, the disqualification of Lindsey Halligan being not appropriately an interim United States attorney.
Right. Which we'll know by Thursday, the Judge Curry says.
In order to even induce or get the fake grand jury indictment, she provided false instructions to the grand jury about Comey's Fifth Amendment rights, about who has the burden of evidence. And then the witness who testified, the FBI agent, saw attorney-client privileged information, and they could have fixed it by just having a different agent testify to the hearsay, but this was the only agent apparently willing to testify, and he was the one guy who you couldn't have testified because he was essentially, perhaps if you wanted to put him on a filter or taint team or segregate him from the case, but he's the exact guy you can't have on the case. So all you had to do to fix this, if you were Halligan, would have been, first, be appointed the right way. Second off, don't bring a stupid case. Yeah. But if you were going to bring this, you would go back, keep the grand jury there, show them the operative indictment, have the right FBI agent who was not exposed to attorney-client privilege go through the information and just provide the correct legal instructions. And then Harry and Ben would be talking about the actual issues regarding the merits of the underlying case, and not that you screwed this up so badly. I know we're going a little long, Harry, but
I want to say just one quick thing, because there's this bewildering array. Here's exactly what happened. His magistrate had issued an order saying 11 problems. Then we had the 12th arise in this hearing, and their response came in to the magistrate altogether on Thursday, but the focus had changed as of the hearing to this. Did the grand jury actually review the operative indictment? And now today,
think about
Comey's coming in. Yeah.
From a grand jury process, the idea that in that process, which happens with regularity, every single day, it's supposed to be across the country, that there would be 12 separate independent defects of what transpired in about a 90-minute to 2-hour period has never happened before. And every one of them is a grounds for dismissal.
Everyone, but I just want to say, especially the misstatements she made about not just his Fifth Amendment rights, but suggesting, there's more evidence out there if you don't like this, not saying what it was. That's the kind of thing, the government didn't even try to defend. They just said, well, you can, if it's harmless error, you can forget about it, but it's not harmless error. And then the vindictive prosecution motion itself, before this flabbergasting moment occurred, it was really going in that direction. So whatever he does with this thing, I think it's really bad, as I say, about credibility and competence, which you don't want to lose a district court on. But I think I don't think the case is going to make it to trial. I think it's going to be dismissed. And there are three things going on. I think was she invalidly appointed? Did she instruct the grand jury, and then was the whole thing vindictive, which that's the basic problem here that unites everything, right? It's all messed up because Donald Trump insisted on a prosecution against a political enemy with having nothing to do with the merits of the case.
Everybody subscribe to the Talking Feds YouTube channel, the Talking Feds Substack, and the Talking Feds podcast. That's Harry's channels. So just search on YouTube, Talking Feds, hit subscribe. Thanks, Harry.
Hey, thank you, Ben.
Love this video? Support independent media and unlock exclusive content, ad-free videos, and custom emojis by becoming a paid member of our YouTube channel today. You can also gift memberships to others. Let's keep growing together.